Hey, everybody, welcome. Welcome to True Crime Wednesday, on True Crime Wednesday, no less, because the last time we saw one another, it was Monday, and we were talking about Lori's sentencing. We're going to continue to talk about that because I'm sure by now a lot of y'all have had an opportunity to watch the recording of the sentencing, and you may have more questions. There hasn't been a lot going on in the other cases that we've been following. Last week we talked a lot. There was a little that happened in quite a few different cases we talked about, but this week there haven't been major developments other than Lori's sentencing and what comes next for her. We do know that the state of Arizona has issued an arrest warrant for her, so they will be, I'm certain, asking the state of Idaho to extradite her. But I don't suspect it's going to happen right away. And we can talk a little bit more about why I think that is. But I just want to say welcome to everybody. I'm going to just let everybody sort of catch up on the live. And as folks are joining us, I do want to point out, I do want to say, first of all, I'm doing very well. My hip's doing great. I saw my surgeon. He told me to go away. That everything looked great and that I was done with any sort of activity restrictions. And so I'm sort of back to trying to get with it. It's still a little sore from time to time, but I expect it's going to be for a while. Everything else is going along great. I'm deeply into the book and working hard on it. And it's a busy process. And so by the time I get to these lives, my brain's full. So be patient with me as we go through. I think we'll just go through what happened in Lori's sentencing now that everybody's had a chance to view the videos. And I think we'll hold it to that, and we'll probably stick to an hour tonight since we've already done an hour this week. But thanks for joining us. I want to remind everyone that any super chats that you send us, any PayPal donations that you can make through the link that's in our show notes, all go directly to our moderator, Michelle. So let's dive into what happened with Lori Vallow's case. So just a little bit of, I don't know, maybe setting the scene. People started lining up outside of the Fremont County Courthouse. Now, for those of you who aren't aware or who, and the few of you, there's only a few of you, I'm sure, that have, I'm turning my phone alarm off. I'm sure there's only a few of you who've actually been in the Fremont County Courthouse. It is an old-fashioned, small courthouse. And so there's was not a lot of space in there for people who wanted to come and see the sentencing. As you all know, I didn't go. Rexburg is about 5 or 6 hours away from me in Boise, and I wasn't prepared. I had to go to Bend a couple of weekends ago for some family business when my aunt passed away. And I wasn't really up to another 6-hour car ride, 12 hours if you count out and back. So I stayed home and, like most of us, caught it on the live stream. However, people started lining up at about 2 o'clock on Sunday afternoon for the Monday morning sentencing. And by the time the doors opened, there were well in excess of the number of people who would ever fit in the courthouse. Now, remember that in addition to the general public, there were seats set aside for family members, victims, and of course for law enforcement that had been there. My understanding is there were a couple of Lori's jurors who came all the way to Fremont to see the sentencing. So they had priority seating along with family members. As far as we know, the press did not get priority seating in Fremont County. They sure didn't get it in Ada County. They had to get on the online reservation system and stand in line the same as everybody else. So the next thing that happened was they began letting people in. I have to say that I felt a little uncomfortable with the fact that there were people lined up who stayed all night on the lawn in front of the courthouse. And there was kind of a circus party atmosphere outside the courthouse. And I found that a little bit disturbing. Maybe that's just me, but it to me smacked of the old days when hangings were public events and were opportunities for the entire community to gather and have a picnic. And I felt like that sort of cheapened the significance of what was happening. And I felt like that was true, especially for the victims who were there to give their statements. So I found it troubling. So the doors opened, courthouse filled quickly with spectators, as well as friends and family of the victims and law enforcement members, the media. Lori was brought in. She was wearing a jail uniform. She was not wearing civilian clothes because she's not really entitled to that because she's not in front of a jury. So she came in her jail attire, including her little rubber sandals. She was in ankle chains, which people who were there said you could hear clanking as she came in. And she sat in between her two lawyers. The prosecution then let the court know that there were people there who wanted to make statements. There were 3 people in person and 1 statement that was read by Rob Wood, the prosecutor. So the first 3 people to give their statements were Samantha Gwillem, who is Tammy Daybell's sister, Vicki Hoban, who is Tammy Daybell's aunt, and then Kay Vallow Woodcock, who it was JJ's grandmother and gave the statement for that part of the family. And then Rob Wood read a statement from Colby Ryan, Lori's son. All of the statements were incredibly moving. They were from the heart. They were given in emotional terms, and they were all very well received, I think, by everyone in the courtroom, except, of course, Lori. One of the things that happened was that the defense at some junctures objected to a couple of the things that the victims said. And a lot of people thought, wait a minute, these victims, this is their chance to speak. So quit interrupting them and just hush up. But it's important to remember that this was still part of the court record. And so the court was obligated to make sure that what enters into the court record is actually factual. The folks are there to express their emotions and to tell the court how the death of Tylee and JJ and Tammy impacted them and their families. But they must not insert into the record things that are not factual. So one of the things that they objected to and which came out was that Vicki Hoban's statement was also submitted. There were quite a few people who submitted statements to the pre-sentence investigation group. And I'll talk about the PSI in just a second. But what came out was that Vicki Hoban had made the statement in her letter that was sent to the PSI folks saying that Tammy had had a pillow put over her face, and that one other thing which slips my mind right now, but the judge rightfully said that cannot go in the court record because there was never any evidence presented at trial that she had a pillow over her face. There was evidence presented at trial that she died of suffocation and that she had bruises consistent with someone holding her down while she was suffocated. But no one ever specifically said somebody put a pillow over her face. So the judge did decide to omit some of those things. And likewise, the judge directed the folks who were giving their statements to keep their statements to their feelings, how things impacted their families, and not to get into the factual matters, because was a matter for evidence to be presented. The reason that's important is because these are statements that are not subject to cross-examination. When these victims give their statements, the defense doesn't have the right, nor the prosecution, neither side has the right to cross-examine them about the validity of their statements. So it is important that the judge act a bit as a gatekeeper and make sure that the record is accurate and factual. Now, y'all know I am not a Judge Boyce fan, but you all know that I'm honest when I talk about what happens in court. And I'm going to be honest about when somebody does a good job too. And I think Judge Boyce did a good job here. I'll tell you why as we go along. I thought that he did a good job in protecting the record and in making sure that the record was factual, and yet giving the victims the latitude to be able to state their minds, speak their feelings, speak their truth. So that was important. The one thing, once the victims had spoken, Lori's attorney, well, there were opening statements by both Rob Wood and John Thomas, one of Lori's attorneys. The prosecution asked for life without parole for straight across the board. The defense asked for life with there really was only one option to be decided, really only one issue to be decided, and that was whether or not her life sentence was going to include the opportunity for parole. That was really the only issue the judge had to decide. So John Thomas got up and he made a plea for a period of time for a life sentence with the opportunity for parole after a period of time. They asked for 10 years. I thought that was absurd, but that's what defense attorneys do. So the prosecution was highballing, the defense was lowballing. I suspected the judge might meet somewhere in the middle. And I think he might have, had it not been for what happened when Lori got involved. So first off, let's talk about pre-sentence investigations, because the pre-sentence investigation played a big role in this, even though it's something we didn't get an opportunity to see and will never see. It's confidential. The judge made the point that the pre-sentence investigation alone was in excess of 400 pages. Now, it was 400 pages, even though Lori refused to participate. So what happens is the pre-sentence packet goes out to victims, family members, lots of people get pre-sentencing questionnaires, they get a packet, and one of the people who gets a packet is the defendant. So Lori got her packet and refused to do anything with it. Generally, what happens is that as part of a pre-sentence investigation, there's an additional mental health evaluation done. Lori refused to participate. So there were opportunities for Lori to really make her case for mercy. And that was the first place for Lori to do that, would have been for her to participate in those evaluations and to participate in the interviews that the pre-sentence investigators do. Because the pre-sentence investigators are going to interview the defendant, and they're going to talk about how the person is going to adjust to jail. They're going to talk about their record while they've been in jail. And they're also, a pre-sentence investigation takes the place of a sentencing hearing in a death penalty case. So in a death penalty case, you have the guilt and innocence phase, and then you have a sentencing phase. And so in all other felony cases, a pre-sentence investigation takes the place of that sentencing phase. And that is the point at which mitigation can be presented to the court to say, you know, Judge, yes, what she did was heinous, but here's all the reasons that might mitigate that. She's got a serious mental health condition. She's, whatever it is, she was a victim of abuse. She was, I mean, there are as many reasons to ask for mitigation as there are people asking for it. So, but the important part is that it's a thorough investigation of this defendant's background. The judge made a point of the fact that here this woman is 50 years old, just turned 50, and had never had a criminal history. She probably hadn't even had a parking ticket before this happened. And how incredibly unusual that is. I know that the judge commented about the fact that she had mental health diagnosis. He named the fact that she had delusional disorder. She had hyperreligiosity. She also suffers from some sort of a personality disorder with narcissistic tendencies, characteristics, go figure. So the judge talked about the fact that Lori had a mental health condition. It was clear, I mean, he had to name that because he presided over discussions about her mental health and whether or not she was competent. So it's clear that he was well aware of her mental health condition. But he found himself unable to really consider that deeply because of her lack of participation, because she would not participate and made it clear that she was not going to allow her mental health to be a piece of the puzzle. Given that, the judge was bound by the information that was in the pre-sentence report. Now, we don't know the information in that pre-sentence investigation report, but they're very thorough. So I'm certain that there were things that were brought up in the PSR that that could have tipped in the direction of mitigation. However, then the judge asked Lori whether she wanted to speak and make a statement before he passed sentence. And she said she did. Now, I have to admit to being somewhat surprised about this. Lots of people have said from the very beginning, oh, she's going to talk. Lots of people said at the end when the guilty verdict was read and she was given the opportunity to say something, lots of people said, oh, she's going to say something. She is too narcissistic not to jump in and think that she can control this and think that she can excuse herself, or she can, and I felt like her attorneys had a little better control over her, at least at the trial, and were not going to let her make statements that would undermine what could be appeals in the future. So I really felt that her attorneys were likely going to advise her not to speak. Well, she said she wanted to speak, and she started out by quoting the Bible, "He who is without sin casts first stone," talking about the judgment of Jesus. And then she launched into, and I'm not going to recite it verbatim. I'm inviting you. It's all over YouTube. Nate Eaton at East Idaho News has it up. There are snippets of it everywhere, so please do go listen to it. Essentially, she says, Jesus knows me. Jesus knows that there were no murders. She said, accidental deaths happen. Suicides happen. And I can't remember how she put it, but fatal reactions to medication happen, but there were no murders. So she doubled down. Not only that the children were not murdered, Tammy wasn't murdered, but then she went on to say, and this sort of fascinates me. This is the first time we have ever heard of Lori claiming that she had a near-death experience. Now, we've heard Chad Daybell talk at length, ad nauseum, about his 2 near-death experiences. We've heard all about Lori being really interested in John Pontius's book called Visions of Glory, in which the character he calls Spencer talks about his near-death experiences and his visions as a result. We've heard all about Julie Rowe and her near-death experiences and her visions. Chad published Julie Rowe's book. He published Suzanne Freeman's books on her near-death experiences. So near-death, the whole concept of near-death experiences, and that it gives a person somehow, what Chad said is it pierced his veil, and so he could now talk to people in heaven and have visions of people in heaven. This is the first time we have ever heard Lori Vallow claim that she had a near-death experience when she was giving birth to Tylee. And she claimed that she left her body, that she saw her dead sister Stacy, that all of that experience led her to be able to talk to people in heaven, and that she had talked to both her children, and she had talked to her friend, Tammy Daybell. She later calls her eternal friend, and that they were all happy. They were all busy in heaven. They were all happy, and none of them blamed her. And so it was clearly doubling down. It's also clearly going down the hyper religiosity and delusional rabbit hole. Now, I know there's lots of people out there who think that she has put this on from the beginning. I'm not so sure, only because a lot of really smart people have evaluated her and found that she was not malingering. That doesn't mean that it can't happen. We know it happened with David Bryan Mitchell, who kidnapped Elizabeth Smart. He was able to fool people for almost 8 years before Dr. Wellner, whose name came up in this case, was able to spend time with him and evaluate him and to discover that he, in fact, was malingering, and he went to trial after 7 or 8 years of being incompetent. So it happens. But I'm convinced that at some level, Lori has a mental health issue. We saw some lovely comments from both from Lori's family. For really the first time, we saw some comments from Lori's sister Summer, from Lori's brother Adam, and her uncle Rex. Now, Adam Cox and Rex Connor, who is actually Tylee and JJ's great uncle. He is Janice Cox's brother. Have a podcast that they've been doing, and apparently they're also writing a book, which I'm sure will have more personal memories of Lori and Lori's family prior to these murders happening. But they all made statements, important statements, about how this has impacted their lives. I don't think that it is all that hard to understand how a person would look at their own sibling and think, she might have some serious problems, but I cannot bring myself to believe that she would end the lives of her own children, or that she would end anyone's life. So I don't know that they can be faulted for finding what was happening bewildering and unbelievable. And it really was not until the children's bodies were recovered out of Chad Daybell's backyard that reality really came crashing in for these folks. And they have been trying to make sense of it in their own individual ways, in their own emotions ever since. And they've gone about it in different ways. Some parts of the family have said, I'm not talking to anybody. Some parts of the family have talked. Some of the other parts of the family have have just cut themselves off. I did think I want to mention about get to Tammy's family in a minute, but so I thought it was, to me, as an attorney who's seen a lot of sentencings, I felt that Judge Boyce had given this a great deal of thought. He had done his homework. He had worked through his thought processes. And I think that it is critical for a judge to be able to, in this circumstance, outline for the public and for both sides his thought processes and how he got to his decision. Because the thought process in the law is often as important as the decision. You can make a great decision for the wrong reasons and get overturned on appeal. So I thought that he did a really good job of sitting down and outlining his thought process. And it was very clear from that he had given it a lot of thought and a lot of consideration and done his homework. For me, I did not feel that he had made a cut and dried concrete decision about whether or not Lori was going to have the opportunity for parole until he heard her statement. And I think that he was offended. I think a lot of people were offended. Maybe not personally, but I guess what I'd say is her statement offended his sensibilities. He said, and I thought really rightly so, he said, you came to my community, to the community that I have worked and lived in my whole life, and you brought your children here with the intention to end their lives. And there were at least 1,000 people out there who would have readily taken your children. 1,000 strangers from this community who would have readily taken your children and saved their lives. And you chose to end their lives. And I thought that was very poignant and very well said. So I was impressed with that piece of it. I did also think, and I admired Judge Boyce for this, because he went into it thinking that he was as fully informed as he could be, and thinking that he had done as much of the thought process and the thinking in advance that he could do. But I, for one, felt that he did not for certain make the decision that she was not going to get parole until he heard her comments. I have to say that I was disappointed by the defense and the comments that they made. I found them a little bit disingenuous and maybe a little offensive. One of the things that I thought sounded a little tone deaf to me was John Thomas, and I made a note of it because it was so tone deaf in my opinion. When he stood there and he said, "I've been praying about this day, and I've been praying for my client, and I've been praying for," if you're a praying person, then you don't reserve your prayers for the worthy. You pray for those who need your prayers. Certainly, they all needed prayer. So that part wasn't so offensive to me. But when John Thomas said, he quoted Martin Luther King, and he said, "Darkness cannot drive out darkness. Only love can drive out darkness." And I thought, considering the whole light dark thing and the fact that Tylee and JJ had lost their lives, and Tammy, because they had become dark, to me, him saying that was really tone deaf. And it bugged me. It bothered me. The other thing that he said was Lori's motto is "love is key." And I am thinking to myself, okay, well, you love money and you love Chad Daybell more than you valued the lives of your children and the human life of Tabby Daybell. And I could certainly see, based on those statements, the judge thinking, I'm not hearing anything that makes me want to be merciful. I will agree, and I would have made this argument had I been in John Thomas's shoes, that life without parole doesn't give the defendant any incentive to be their best self in prison. And perhaps we don't care whether Lori is her best self in prison or not. We don't care. We care that she's not out in the world where she can inflict any more pain or any more damage on the human race, and on particularly on people she loves or that loved her. However, it is important for the justice system, for the corrections system, that they have the ability to moderate people's behavior. And it's much easier to moderate the behavior of someone if they have a hope that can be held over their head. So while I didn't see that John Thomas's argument was one of you have to give Lori hope because that's a human thing to do. But giving Lori hope then means that she may behave herself better in prison and make life easier for the people around her. Hopeless inmates are not easy to manage. So Lori also pointed out that Tylee had pancreatitis. Summer said she remembered 7 instances where Tylee had pancreatitis. Now, I've not had pancreatitis. I have been told it is incredibly painful and that there is very little that can be done except to ride it out. I mean, medical, they can be given drugs that help with the inflammation, with the, with all of those things, but ultimately it is riding it out. I cannot imagine a mother having to sit next to her child's bedside and hear her child scream in pain and writhe in pain and not have that impact you, not having it change you. But I certainly cannot imagine Lori making the argument that Tylee has now been spared a future of physical pain. And she did make that argument that Tylee had been in pain on and off all her life. Her body never worked right. And then she also doubled down on that Tylee was abused by Joe Ryan. I am not in a position to judge. I can tell you that her Uncle Rex, having gone through all of the same documents that most of us have seen having to do with her divorce with Joe Ryan, doesn't believe it anymore. So I am not in a position to invalidate anyone's truth, and I will absolutely not do that for any victim, and that includes Colby Ryan. And both things could be true. So I'm not going to judge one way or the other, but she did double down on it. The judge was very disturbed that she did not cooperate with the PSI because it was her choice. And the fact that she made that choice contributed to his decision. And, he did go through all the factors. He did note that something radically changed with Lori somewhere around 2017 or 2018. We all know that. We've heard it from so many people. And that her own mother said she is not the person that she was. She's not my child. I thought it was very interesting that I listened to Lori's Uncle Rex Connor's interview with Justin Lum today. And he said his daughter commented about the trial. So this would be Lori's second cousin, because he's a great uncle. His daughter commented at the trial, "It feels like I am at Lori's funeral. The Lori I knew is dead, is gone. And it feels like, in a way, that I'm at her funeral," which I thought was a really interesting observation. I think ultimately the judge was moved by the fact that Lori showed no remorse. And I think that was finally what cemented for him the decision not to allow her to have parole. I did want to mention that in Samantha Gwillin's, I believe it was Samantha, it could have been Vicki Holben. I'd have to go back and listen to it again, but one of the two statements from Tammy Daybell's family, she remarked that it was very unfortunate that Chad's children had not come to their grandmother's funeral. So when Tammy's mother died, Chad's children did not go to their grandmother's funeral, and they have continued to be distant and removed from Tammy's family. I don't know that that's all that unusual. They had to pick a side, I guess. I don't know that it's all that unusual for them to be distancing themselves. They may very well be distancing themselves from Chad's family as well. I don't know. But I thought it was unfortunate because she made the point that it would have been an opportunity for there to be some healing, and that hasn't happened. So I thought that was sad and unfortunate. So I have blah, blah, blah on for a while. So let's take some questions and hear what you all have to say. We can take a minute while Michelle is pulling up those questions, because there were I got a couple of questions about some motions that were filed in the Brian Koberger case. So while Michelle is getting her thoughts together, I'll just interject this. And if you want to see a good rundown on the legal issues of this, Harvard lawyer Lee, her live from, I think, earlier today, goes into the legalities of this. But there has been a motion to dismiss the indictment against Brian Koberger. Now, we all know they asked for an alibi notice, and the defense kind of, sort of did it lip service. Now the prosecution's saying, you didn't give us your alibi, so now you can't raise one, and the judge has to rule on that. So, but there's been this pending motion to dismiss the indictment, and I thought it was fascinating from the lawyer nerd law wonk standpoint. And that's that they argued, which was fascinating to me, that Idaho initially required that a grand jury find beyond probable cause beyond a reasonable doubt. And those two things don't make any sense when you put them together, because probable cause is such a low standard. It's more likely than not that a crime was committed and this guy did it. More likely than not. Now, that sounds kind of like 51%. So, but they made the argument that historically, when the Idaho Constitution was written, it was intended that it be a higher standard of proof for a grand jury. Now, the legal arguments make a little bit of sense if you think about them. Because a grand jury, I got to shift. My hip still doesn't like it when I sit it for too long in one position. The argument between a grand jury and a preliminary hearing is that in a grand jury, only the prosecution presents evidence, and the grand jury only hears the prosecution's side of the case. If there's a preliminary hearing, as there was in the initial charges against Chad having to do with the evidence tampering, the defense at least gets to cross-examine witnesses and sometimes puts on their own witnesses, particularly if there's an alibi. So their argument was that the state of Idaho intended there to be a higher standard for grand juries, but that historically rules that were promulgated in New York, of all places, began that sort of trickle down, and that over the last 100+ years, the standard for grand juries has gotten watered down to the same standard as preliminary hearings. Fascinating. Is it going to go anywhere? Absolutely not. Here's why. Because not only has the Idaho Supreme Court, but the federal Supreme Court, it is long-standing law that the standard is probable cause in a grand jury. That they're not going to go back and unring that bell 100 years later. It's just not going to happen. But it is a really interesting argument. So a lot of people said, why in the heck would they go out and spend all this time and make that argument if it's not going to go anywhere? Good question. The answer is because that's how we make new law. That's how new law gets made in our country. Because what'll happen is the judge will deny the motion to dismiss the indictment. He'll say, interesting argument, thank you for sharing, and deny the motion. Then what will happen is that the defense will appeal that decision, and the Idaho Supreme Court will have to take it up. And it's a novel issue. And it probably is an issue that some legal wonk sat down and did all of this research back into the annals of US jurisprudence and discovered, wait a minute, this was never supposed to be this way. We've been doing it that way for the last 100 years, but it wasn't supposed to be that way. So it's fascinating if you're a legal wonk. And I think it will be interesting to see if it percolates up channel. Is it going to help Bryan Kohberger? Absolutely not. I don't think it's going to do anything at all for Bryan Kohberger, but it's a fascinating legal issue. So for those of you who come to hear me talk about legal issues and the little nuances of the law, that's your trip down into the weeds for today. Now, I usually reserve those trips down to the weeds for the newsletter, but you all know I'm writing my butt off these days and don't really have as much energy to get newsletters out. So, hi, Linda. Lori, is it hard for defense attorneys in a case like Lori's when the evidence is so overwhelming? I know they have a job to do, but it must be hard. What are your thoughts and your opinion? It is hard. It's really hard. And for the most part, now I have a little intel from inside and have been told that Lori's lawyers, at least one of Lori's lawyers, is not a huge fan and was pretty outraged at what Lori said during her sentencing because it was off script. It was not what they had discussed in terms of what she was going to say. So, defense lawyers are human. We don't like all our clients, and I can say that I had clients I really didn't like. But I think that as a defense attorney, you go into it hoping that you can, first of all, it's very difficult to advise someone and have them trust you and take your advice if they don't think you value them. If you go in acting like this person is a piece of crap and has no value, then you're not going to get very far with that person. So it's important as a defense attorney that you find common ground. Now, does that mean that you lie to your clients or that you ingratiate yourself with your clients? Absolutely not. And anybody who I represented will tell you, that woman will tell you the straight scoop. I mean, I have a woman who I represented a long time ago who she and I still stay in contact. She's an amazing person. And one of these days I'm going to get her on here and introduce her to all of you because she's a rock star. But she was involved in an armed robbery. And she came in, she was surly, she was mad, she was coming down off meth, she was not a happy camper. And she said to me, I am not going to effing prison. And I looked at her and said, honey, I'm a really good lawyer, but I am not a magician. And I do not have a magic wand, and I cannot make that happen. Now, let's talk about reality. And she and I are still fast friends. So it is a hard job, and it is a hard job to sit with someone and to tell them hard truths. I did have a passing thought, and I don't know. I wondered whether Lori's relationship with her counsel would have been different if one of them had been a woman. I don't know. Maybe it would have made any difference at all. Maybe Lori would have thought, oh, here's a girl I can be girlfriends with. And that would have been a mistake too. I don't know. But I think it's interesting to think about because the dynamic between her two attorneys, she in trial, she tended to kind of bounce, you know, when one of them wasn't sort of giving her the response she wanted, she would kind of bounce to the other. I think from John Thomas's remarks, he was more sympathetic to the hyper religiosity than it appears maybe Jim Archibald was. I don't know. But it is difficult at times to sit next to somebody and to say, this is going to be really painful. It's going to hurt a lot. And I'm going to be here and I'm going to do my best for you. And I'm going to give you all the support I can. But you need to understand this is going to be a super unpleasant experience. And that doesn't go just for being a criminal defense attorney. It really goes for being a lawyer in a lot of ways. I mean, I did a lot of family law too. And I guarantee you that there were very painful court proceedings that happened in cases that I was involved in. So this is a great question. I think that defense attorneys have to really search their own souls and do a little introspection and think about their own motives in why they do what they do. I loved criminal defense. There was always something new to learn. There were novel things to tackle. And there was also the human element of having a person sitting next to you and there being that the stakes makes the stakes more important, more significant. Thank you for giving me the chance to hop on my soapbox. Mary Miller, thank you so much. Thanks for your sweet comment and thanks for your super chat. Michelle appreciates them more than you know. Hi, Julie. Hey, Julie. I'm sorry that we couldn't get together for lunch this week, but let's try and do it next week. Julie's a local here in Boise, and I got to know her. She actually sat in on the last week of the trial for me, for Lori's trial, because I was in California getting my daughter married off. So what did I think of her speech? I thought it was kind of sad. I thought there's at least a 50-50 chance that she actually believes this stuff, which I thought was troubling. And I thought it was a little, I thought it was very misguided and a little disingenuous. But I don't know that I've heard worse in terms of, you know, getting your gun out and shooting yourself in the foot. But defendants are unpredictable, and particularly ones that have some pretty serious mental health issues. So let's do lunch soon. Hey, Squeaky Wheel. Could you arrange for Lori to meet us here for a live stream some night? Oh, I sure wish I could. So since we know that Lori and Chad can portal to where they need to be, and Lori appears to be able to pierce the veil, let's see if we can invite her to come and join us for a live stream. I have lots of questions too. I'm not sure I would want to know whether Chad wears boxers or briefs, because the image of Chad in tidy whities is something I could never get out of my head. I would have to claw my eyes out. So thank you. Thanks for the laugh. I would love to have Lori portal over here and join us anytime. We did see that the state of Arizona has filed an arrest warrant, and I did want to talk a little bit about when I think that will be that'll be executed. So while Michelle's looking for other questions, 690 people in chat tonight. Thanks so much for joining us. I really appreciate that. Please hit the like button. Please subscribe, and please share it and tell your friends, would you? We noticed over right after the trial, and then over the period that I was laid up and not on so much, our numbers went down a little bit. So if you have a friend who hasn't heard about us yet, share it on. So to talk about what happens now, Lori was transported to the Pocatello Women's Prison yesterday. We got her probably her last mugshot, or one of her last. The next thing that happens is she will go through an orientation and intake period, usually about 30 days. Usually they do evaluations, they get an orientation about how to behave and what the rules are and what goes and doesn't go and how to function in prison. And then they're moved. And a lot of it depends on, part of the evaluation is what's the best population for this person. Do they need to be in a segregated unit for their own protection? Do they need to be in a mental health unit? Do they need to be in a unit where they could get substance abuse treatment? I mean, there's a number of evaluations that go into where Lori will be housed. Then they'll make a decision about her housing. I do not believe that Arizona is going to, Arizona and Idaho are talking to one another. Prosecution's talking to one another. The prison system's talking to one another. And I don't believe that they are going to extradite her until she's done with that 30-day intake. Once that's done, she's fair game. And then I think we'll see that arrest warrant get served and they will file their request for extradition. Generally, what happens is if she agrees to extradition, then they can move her. Otherwise, they have to get a governor's warrant. It's a very administrative process, and it is necessarily has to be a rather cumbersome process because we have this state sovereignty 14th Amendment to our U.S. Constitution. And so one state can't tell another state what to do with their citizens. So the next thing that will happen is they will do all that administrative stuff, but I would not be surprised to see it take 30 days to maybe as much as 90 days for that whole process to happen. So, any more questions? My prediction is to Chad's defense. What will it be, and will there be a plea? Hi, Beth, by the way. I think that Chad is still, if he's smart, he is still considering a plea. He is still facing the death penalty. Now, knowing what we know about how long it takes to get somebody actually executed, particularly in Idaho, where the last person that they issued a death warrant for had been on death row 35 years and had fully exhausted all of his appeals. And then at that, they had to void the death warrant because they couldn't get the necessary drugs to issue the lethal injection, to administer the lethal injection, which is why the state of Idaho has recently reinstituted the firing squad. It will be interesting to see whether how that's going to play out and whether or not that is going to be sort of retroactive, whether or not there's going to be any option for if you received the death penalty and were sentenced to death by lethal injection, can the state change that? I think the answer is no, but it'll be interesting to see that play out. So I think Chad's defense is going to be, I wasn't there when it happened. I wasn't involved. I was swayed by a pretty face. This was all Lori and her brother Alex. I didn't have anything to do with any of it. And that is going to be a harder sell when it comes to Tammy's death. As far as we know, Chad was the only one in the house at the time that Tammy died. I think his argument for Tammy's death is going to be it was natural causes. She didn't suffocate. They're wrong. And I'm not guilty. I didn't hurt her, So I think they may go there. They may challenge the autopsy results, and I think that may be how they get around Tammy's death. But I think he is certainly going to say this was all Lori and Alex, and I didn't have anything to do with it. I think that's a tough sell when there are phone pings in his backyard. Alex is in his backyard. There's phone pings in his backyard, and the children's bodies are found in his backyard on his property. So I think it's going to be a tough sell, but I don't think they have anything else. And we have heard from the beginning that the prosecution felt they had a stronger case against Chad than against Lori. So if that's the case, he might be smart to take a plea. I think that if Lori had gotten a sentence that included some hope of parole, he would have taken a plea right away. I think it's a harder decision when it's life without parole. So, because I don't think the prosecution is going to offer him anything that Lori didn't get. So I think they're going to offer him the same thing she got, 3 consecutive life in prison without parole sentences. And he might be smart to take it. So, but we'll see. We'll see whether or not he's ready to put the prosecution to the test. Hi, Sylvia. The defense implied that the prosecution, the defense, and the court collaborated to get the death penalty taken off the table. That's just BS. It's not true. What happened, and for those of you who've been following me for a while, I've done a couple deep dives on this, but sort of on the surface, what happened is the prosecution is obligated by law, by statute, by the U.S. and the Idaho Constitution to give the defense everything. If they turn something over in their investigation, it has to be shared with the defense. The prosecution doesn't get to decide whether something's important or significant or relevant or any of those things, because the purpose of discovery is to allow the defense to investigate all of the facts of the case, including anything within the discovery that might lead to exculpatory information. Okay, so you don't have to show that information that the information the prosecution has could lead to your client being not guilty. All you have to do is show that the prosecution has discovery they didn't give you. You can't tell whether what they have could lead to exculpatory information because you don't have it. You don't know what you don't know. So the judge set deadlines for discovery. Now, both defendants' counsel had complained about the prosecution not complying with their discovery obligations. And the prosecution did this song and dance and whined about how voluminous the discovery was. But the prosecution spent $3.6 million before Lori ever sat down to trial, and they didn't hire a discovery clerk. Now, most big prosecuting offices have discovery clerks. Their whole job is to just keep track of what discovery has been provided to the defense and what hasn't. But in these really small jurisdictions where you might have 1 or 2 administrative people who work for 1 or 2 lawyers, you need to hire somebody whose only job is to make sure that every piece of discovery, every electronic file, every piece of paper, every text message gets sent to the defense. So the judge set a deadline before trial of when he wanted that all of the discovery to be completed. And the prosecution messed up and they did not provide discovery. Now, some of it was late discovery because there was a late discovery of the hair that was in the duct tape that JJ was wrapped in. And they were unable to get it tested, and they had to send it across the country to an out-of-state lab, a specialty lab, to get it evaluated before the trial. But there were things that they just messed up and didn't give them, including hundreds of jail calls, hundreds of hours of jail calls. Now, anybody who's done defense knows that that jail calls can be a gold mine, because people lose track and forget, even though they're told at the beginning of every phone call, this phone call will be recorded. They forget. They're talking to somebody they know, they're talking to their loved one, and they can be a gold mine. So they weren't turned over. In addition, there were FBI interviews when the FBI went back and did second interviews on a bunch of people they'd interviewed before. They gave the defense the written reports of their interviews, but the defense didn't get the recordings. Now, there can be a lot of variation between what an FBI agent says was said in an interview and what actually happened. There can also be a lot of body language if they're videotaped. So they wanted the recordings themselves, and they didn't get them. So the judge, recognizing that there had been a lot of discovery violations, complaints about discovery violations early on, said, there is no excuse for this. No excuse for the prosecution not giving them the discovery that they were entitled to. So what's the remedy? What do I do about this? And the answer was different for the two defendants, because Chad Daybell had already waived his speedy trial right and said, I'm in no hurry. So judge, give me extra time. But Lori Vallow said, I've not waived my speedy trial. I'm not going to waive my speedy trial, and I'm going to make you take me to trial within my speedy trial rights. Now, the judge had already extended that by 41 days, which I think is going to be an issue on appeal. There was no way he could say, well, I'm going to extend this out another 6 months and let them listen to these hundreds of hours of jail calls or whatever. So he decided that there were going to be two results from this. One was he was going to finally, after denying it for umpteen times, sever the cases. So he was going to say, okay, Mr. Daybell, your trial is off, and you get extra time to look at all that discovery that you didn't have time to go through. And okay, Ms. Vallow, you're going to go to trial within this speedy trial rights. But there still needs to be a penalty, a remedy for the fact that the prosecution didn't give over the discovery that they were supposed to. It's not enough just to say you can't use any of that at trial, because that doesn't remedy the real problem. The real problem is, was there anything in those hundreds of hours of jail calls that could have led me, that was a clue that could have led me to new information? And that's something you can't know if you never got them. So the judge said, it's not enough to just say, we're not going to use it, or the judge to order, you can't use it. So what the judge said was, and this was again a novel idea, because it hadn't been done in Idaho before. There wasn't case law to support it, but the judge looked at case law in federal court. He looked at case law in other jurisdictions, and he looked at the statute that gives him authority, gives him his power, and determined that he had the power to dismiss the death penalty. The prosecution absolutely did not collaborate on that. They did not want the death penalty off the table. They wanted to go forward with the death penalty, and they got their hands slapped, and the death penalty was taken off the table. So I don't know what I think, I don't know. I'd have to go back and listen to what they said, because there was no collaboration about it. It was purely a punishment for the prosecution not doing what they were supposed to do. I think that the defense attorneys felt like that was a triumph on their part. It was a win for them because they got the death penalty off the table. And that may have been what he was saying. I don't know, because I'd have to go back and listen to it. But it absolutely was not a collaboration. The judge, it was clear that the judge was penalizing the prosecution. Intervisions. If Lori's convicted in Arizona, which sentence will she serve first? She'll serve the Idaho sentence, which means she'll never go to Arizona. But that doesn't mean that it is any less important for Arizona to prosecute that case and to get a conviction for Charles. It recognizes that Charles was victimized, that his life was taken, and that he needs his own justice. Just convicting her on the deaths of the children and Tammy isn't really justice for Charles. So even though she'll probably never see the light of day in Arizona, she'll go there for trial, and then she'll come back to Idaho to serve her sentences here. Hi, Jay Bailey. Will the prosecution be able to use the same witnesses in Chad's case without risking that their testimony deviates slightly and prior calls perjury? Well, yes, and yes. The prosecution can and will, I'm certain, call the same witnesses. John Pryor and his team are certainly going to. That's the reason why they wanted the transcripts from Lori's trial, was so that they would have the written transcription of all of the testimony and be able to look at that when the person's testifying in Chad's trial. Slight deviations are not going to have anybody yelling perjury. But I think that it is an opportunity for John Pryor to impeach witnesses, to say, well, in Lori's trial, you said this. If they're vastly different, I think it's a problem for the prosecution. Minor deviations, I'm not so sure that would rise to the level of disqualifying a witness or accusing them of having perjured themselves. Because everyone's testimony is going to deviate slightly. I mean, all you have to do is go and listen to the interviews that Melanie Gibb gave to, and I know this because I was doing it, the interviews that Melanie Gibb gave to Nate Eaton early on in the case, that she gave later to her testimony at the preliminary hearing, and then her testimony in trial, to see that there were minor deviations. Time goes by, memories fade. It's not at all unusual for testimony to deviate slightly, and that's not perjury. That's just, I remember it different now. But it is an opportunity for John Pryor to get in and say, but didn't you say, and then to call that person's memory and that person's testimony into question. So, and I mean, anytime there is there's sworn testimony in a prior court proceeding, that's the case. Whether it is co-defendants or whether it is a civil case, or anytime there's sworn testimony. I mean, in civil cases, we take depositions, they're taken under oath, and lawyers do that for that purpose, to be able to preserve somebody's testimony. And then when they testify 2 or 3 years later, be able to say, but didn't you say at deposition this happened? So it's a common practice. Hi, Kathleen. Judge Boyce has seen a huge amount of info in Lori's case, and that also applies to Chad's trial. Can he be unbiased in Chad's case? This is always a dilemma when you have co-defendants and they're going to be heard by the same judge. I think that when you, if he were passing judgment in that he were the finder of fact, it was a bench trial, I think it would be more problematic. But he is the judge in a case like this is really, where there's a jury, is a traffic cop. They're really, we always like to say, they call strikes and balls. They're the umpire of the trial. And that's a different role for a judge. So he doesn't have to decide whether who he believes. He doesn't have to decide whether he believes this expert or that expert. He doesn't have to decide whether he believes anybody who's going to testify for Chad. He only has to make sure that that information is presented properly to a jury who's going to decide who they believe. So it's less problematic when the judge is presiding over co-defendants and not being the finder of fact, not ultimately deciding guilt or innocence. Good question, though. You know, I always have to say, we all have been together long enough, and you all have been joining us, and there's over 700 people here tonight. Thank you very much. You all have been with us for a long enough time that you guys don't ask lightweight questions anymore. We've talked about all those issues, and now it's fun because I hear the legal questions that make me think. KCL, Chad's also going to have fun trying to describe away his infamous raccoon text to Tammy. That is absolutely right. I mean, it is certainly an ill-timed, strangely timed text, and that had slipped my mind, but you're right. So it is going to be difficult. If I think about it, I'll pull up the little meme that we had at one point. There was a picture of a raccoon dressed in clothes with a little tag that said, "I'm ready for my subpoena, Mr. Pryor." Is Pryor going to ask for Lori's sentencing statement? Well, he doesn't have to ask for it. It's out there everywhere. So I don't know that he has to ask for a transcript of what happened during the sentencing, because it's out there, and he can, it's 20 minutes. It can be easily transcribed if he wants it. It might be more likely that he'll play it at trial to prove that she was the person who was hyper-religious. She was the person who was believing all of this stuff, that it didn't have anything to do with Chad, that she was the driver of all of the sort of weird religious beliefs and the cult activity, and he was being sort of pulled around by his private parts. I mean, I think that could be an argument. So we're about an hour and 15 minutes. So we'll take a couple more questions after I answer Janelle's, and then we'll say goodnight. Janelle, does it seem to you that Lori had some power in the courtroom? For example, not being televised, or the way she was placed in between her lawyers so she not be seen so much? I don't know that I would call that power. I think early on in the case, the hearings, the pretrial hearings, were being live streamed. And I certainly can understand the issue of live streaming pretrial motions. I do think that it could have an impact on getting an impartial jury. So the defense complained because at one point, I believe it was Court TV, and in collaboration with East Idaho News, were doing the live stream. And the cameras, as far as I recall, are run remotely. So they were able at times to zoom in really tight on Lori. And I mean, if I'd been the defense attorney, I would have complained about it too. It was intrusive. Now, did Lori know they were zooming in on her all the time? No, she didn't. There's no monitors. There's no way to know what is being live streamed from the counsel table. But her attorneys afterwards said that was really a little over the top. Now, the judge had put guidelines into place, and the judge was quick to point out that the live stream, the court videographers, whoever was doing the stream, didn't do anything that violated his guidelines. But he was concerned that what they had done was fairly intrusive. What really tipped him over into saying no cameras, period, was that the prosecution said, oh, we don't want cameras. We're in support. We don't want any cameras at all. And I think that was the problem. So I don't know that she had a lot of power having to do with the cameras in the courtroom. It is not unusual for a defendant, if you have two lawyers, for them to sit in between, because there are discussions that go on between lawyers and their clients during trial. A lot of discussions. They take notes, they pass notes, they whisper to each other. And so it is not an unusual place for her to be. I did have somebody ask me whether or not she purposefully lowered her chair so that she was so low in between her lawyers. And I don't know that because I wasn't in the courtroom. I can tell you I'm short, and I used to very often have to go in and adjust the counsel table chairs because somebody who was really tall had just sat there, and I was like I was at the kids' table. So I don't know whether it just happened that chair was low or whether it was purposefully lowered so that she was down in between her lawyers. She's not a large person, and Jim Archibald is a very big guy. He's well in excess of 6 feet tall, and he's big. So it wouldn't be hard for her to hide behind him. You will note at the trial and at the sentencing that he sat on the outside. So he was not blocking the view of the gallery in the trial. John Thomas is a shorter guy. So Lori could be seen past John Thomas. I don't think you could have seen her if she had been, if Jim Archibald had been sitting there. So I don't know that she had that much power in the courtroom. Defendants are pretty powerless. They are there when they don't want to be. They're there under a court's order. They're there shackled, wearing their jail clothes and their little jelly shoes. And I mean, it's not a pleasant experience. And I think they're often the least powerful person in the room. You know, even when they're given the right to wear their street clothes, still, you know, they're definitely somewhat disenfranchised in a courtroom. They're not the person who knows what's going on. They have no control over what's happening. And they often don't really, because so much that happens is legal jargon and discussions and motions, and they don't necessarily always really fully understand what's happening in the moment. And so I wouldn't say that she had much power in the courtroom. Let's take 2 more questions. Sandra, if Chad does take the plea, will they require him to be truthful about what really happened to Tylee, JJ, and Tammy? This is a good question, and the answer typically is no. There are times when a prosecutor will say, in order, but it is usually when there are co-defendants who have not yet gone to trial. We will offer you a plea and we'll make you a good deal, but it is contingent upon you sitting down with law enforcement and telling the complete truth. I've cut those kind of deals before for clients. But it generally does not happen in a situation like this because they don't have much leverage. Lori's already been found guilty and sentenced, and there's really no leverage other than we'll take the death penalty off the table. But they're willing to do that because they don't want to try this case again. It was expensive. They all have to come back to Boise for a couple of months. They don't want to do it again. So, I mean, their advantage, the prosecution's advantage is they don't have to try the case twice. They're going to make a plea deal because they don't want to try the case again. There really isn't any leverage that they have at this point to say to him, look, chatty boy, you've got to be totally honest about what happened to the kids. They just don't have the hammer to do it. So, and I'm sure his attorney will be advising him to keep his mouth shut. He is required to enter a guilty plea, and that guilty plea, even if he were to enter an Alford plea, which is a form of guilty plea, and he would have to plead that he was guilty to the murders and the conspiracies. So beyond that, he would not be required to expound on what he did. One last question. We got anything for us? I want to remind everybody, I'll grab Carol's first. Do you think that since cameras in the courtroom for sentencing went so well that Judge Boyce will reconsider them in Chad's trial? I think it's possible, mostly because John Pryor was in support of having cameras in the courtroom. So I think if Chad does go to trial, I think the issue is going to be revisited. Now, whether or not he's willing to reverse what he's done, I don't know. But I will say that I thought that both the verdict and the sentencing went well, and that bodes well for perhaps having Chad's case live streamed. So I would hope so, and I'm sure it'll be revisited. So I want to thank everybody for being here. Remind everybody we're here every Wednesday. I do have a couple of questions for folks. First of all, I want to remind you that if you're not one who likes to post questions in the chat, feel free to add it to our comments here. I do go through them. I haven't been as diligent recently because I've been doing a lot of writing, but I will get to them. And if that isn't, it doesn't work for you because you don't want to put them out in public, feel free to email me. Our email link is in our show notes as well. So I just want to thank everybody for being here. 700 people in the chat is amazing on a Wednesday night. Thanks for joining us. I know that there's lots of other things you could be doing. Thanks to everybody who sent us a PayPal or a super chat donation. They all go to Michelle, and I can tell you she appreciates them more than you could know. So I'm going to say good night. Have a great evening. We'll see you. Before I say good night, the last thing I wanted to ask, and I'm going to put this out in the community chat as well so that people can weigh in. We've had some requests for us to move to Friday night. We moved away from Friday night because of some conflicts. It appears those conflicts are not there anymore. So I'm going to ask you all, what do you think of Friday night? You let us know. Drop us comments, drop us emails, and I'll put it out in the community chat, and you can let us know your thoughts. So with that, I'm going to say goodnight. I'm going to thank you all for having been here with us. Thanks, Michelle, and we will see you next time.